Hi everyone, my name is David Grant and I'm the corporate broker here in Las Vegas. I also have over 20 years real estate experience in the Las Vegas Valley. In addition to conducting hundreds of transactions for clients over the years, I am also a certified and licensed real estate business coach with Tom Ferry International and have over 2,500 hours of coaching and mentoring experience. Today we're going to talk about the very basic elements of real estate contracts. What is a real estate contract? Very simply, a buyer and a seller of a real estate come to an agreement via a written contract to facilitate the sale and purchase of that real estate. Real estate contracts normally are going to be bilateral. It is two as opposed to a unilateral, which is one. They should always be in writing, signed, and dated. Validity of a contract. Let's discuss what actually makes a contract valid. Generally, every real estate contract meets four requirements to be valid. One, you need to have a valid purchase agreement contract and it must be in writing. Two, the contract must contain an offer and an acceptance, place for the buyer and seller to sign and date to make it official. Three, the purpose of the agreement must be legal, cannot be deceptive. We want to go into this contract in good faith, everybody. Four, there must be an exchange of things of value. Usually it's for money, for property. Now, when you have a purchase contract, there are going to be contingencies within that contract. There's normally about 4 contingencies in Nevada real estate contracts, but not limited to the following. You're going to have a financing contingency. And essentially a financing contingency talks about the buying power, if you will, of the buyer. They have to qualify for a loan and within that time frame execute the purchase contract. 2, there's going to be an appraisal contingency. And essentially the appraisal contingency talks about, hey, buyer A has offered to buy a property for example, $250,000. The property needs to appraise for at least $250,000 or higher. Otherwise, the appraisal contingency can come into play. 3, we're going to have a home inspection contingency. During a due diligence period, which we will get into later, we talk about a home inspection. Now, home inspections are not required. However, they are recommended that you have that so you can kind of go into it with open eyes, if you will. And 4th, if applicable, homeowners association. The buyer has 5 days from the date of receipt to review the homeowners association's rules, regulations, bylaws, and budgets. Those are generally the 4 contingencies you will see within a real estate contract. Contract misrepresentations. Okay. Misrepresentation is basically doing something deceptive of a material fact made by a party who believed to be true. So let me backtrack for a second. Maybe they're making a statement that they believe to be true, but in fact it is not. That would not necessarily be a deceptive misrepresentation. There could be many things that could be misrepresenting the homeowners association fees, property taxes, size of the property, lot size, zoning. So make sure you do your due diligence during that contract period so that you understand the facts to be true as you know it. Contract mistakes. Essentially, there's going to be 3 different types of contract mistakes. You can have a unilateral mistake, which happens when one party to the agreement is misguided in terms contained in the agreement. Again, whether that's deceptive or in error. Mutual mistakes occur when both parties to the agreement are misguided. And third, a common mistake which occurs if both parties hold a similar misguided belief in regards to that property. Example could be, I believe the square footage of the lot to be 10,000 square foot, as opposed to maybe an accurate reading of 77,000 square foot. Those are the different examples of a possible misrepresentation in a contract. Breach of contract. Generally speaking, breach of contract is when one party to the transaction breaches their obligation to complete that contract. There could be specific terms, acts within that contract where one party doesn't execute as agreed upon, which could dictate a breach of contract. Well, let's discuss damages in regards to a possible breach of contract. Damages can be what one or more party to the contract suffers due to non-performance of that contract. There are generally 5 types of damages. You're going to have compensatory damage, nominal damages, punitive, exemplary, and liquidated damages. Compensatory damage. Damages are awarded in mediation or civil court where losses occurred as a result of the negligence of unlawful conduct by another party. Nominal damages, those are generally very minimal damages where maybe one of the parties did not suffer a severe financial loss. That could be nominal fees such as court costs, attorney fees, things of that nature, or a cost to go through mediation. Punitive or exemplary damages are essentially where one party has committed fraud, had intent to fraud the other party. Generally speaking, through mediation or a court of law, they're looking to make an example of that other party. So you can not only have cost of what the damages were, attorney fees, and additional fines and penalties because they want to discourage that act from taking place ever again. Liquidated damages, this is generally a term that you will find in most, if not all, real estate contracts. And essentially what liquidated damages talks about is an agreed upon dollar amount. If one party should breach that contract, that dollar amount will be rewarded to the other. In most cases, that's going to be if a buyer were to default in the contract, they would release their earnest money deposit as liquidated damages to the seller with no further legal obligation. All right, now we get into the fun stuff, guys. Talking about securing an offer. How do we secure the offer? First off, you must understand not only what your client's needs are, but you also need to understand the consideration for the other party as well. You need to educate the buyer in the process of purchasing that property. And by educating the buyer, you need to make sure that you, as the real estate professional, are doing your best to provide knowledge to that client. Preparing that offer, you want to make sure your client is educated on what the values are within that neighborhood. So for example, if we're writing an offer and the list price is say $250,000, is that a price that is actually relevant, or is the price too high or price too low? Okay. Secondly, you've got to make sure that your buyer's pre-qualified. Now, one of the best practices is, generally speaking, when you start to work with a new buyer, you're going to ask that buyer, "Hey, Mr. Buyer, how do you intend to purchase this property? Is it with cash, or do you need to take out a loan?" And in the case of taking out a loan, we want to make sure that they are pre-qualified for that property. 2 main reasons for that. Pre-qualifying the buyer, number one, gives the buyer the actual confidence and purchase power, if you will, on how much home they can actually buy. Benefit number 2 of the pre-qualification essentially says, hey, when we find that home that we want to buy, we can act on that property, as opposed to now let's go get pre-approved with the lender. Make sense? Absolutely. You have to create a strong plan to also help identify the properties that your client wants to see. So we actually kind of went a little backwards there, if you will. But once we pre-qualified them, now we want to go find out what property you're looking for. And those can be variables. Specific part of town that your buyer's looking for. Square foot, how many bedrooms, how many baths? Do we have a preference for single story, 2-story? That way, by developing this search criteria for your buyer, you're help setting them up to, 1, look at the properties that they actually can financially purchase. 2, the properties that meet their needs. The other thing to keep in mind in this process, you're never going to find the perfect house for your buyer. So there's going to be a little bit of give and take during this process. Negotiation. This process basically refers to how are we going to negotiate representing our client with the other party in the transaction. There's all different variables. Pricing, the house priced correctly, overpriced, undervalued. Timelines. How soon does the buyer need to move into the property? How soon does the seller want to vacate the property? So there's going to be negotiations in all phases of the purchase contract, not just accepting the contract, but as we move through the contingencies of a purchase contract during inspections, any appraisal issues, things of that nature. Better negotiating. First, as I just briefly mentioned, you must understand your client's needs, but you also need to have consideration for the seller. We've talked about timelines, pricing, inspection contingencies, things of that nature. You have to listen closely to your buyer. What are their expectations? You need to educate them going through that contract process of the potential pitfalls, timelines, and how we can negotiate through those timelines. You have to remember, folks, at the end of the day, we're trying to achieve the best outcome for both parties. I like to call it a win-win situation. Negotiation approaches. What are different techniques for the best outcome for both parties? There could be specific needs as we discussed in the slide before. When does your seller need to move? If a seller has a longer closing timeline as opposed to what might be customary, and just so you know, customarily in a financed offer, that's going to be something that's going to be probably 35 to 45 day timeline. Okay? But maybe that seller has some specific needs where they need to stay for 60 or 70 days. Do we have a longer escrow period? Or do we have a normal escrow period and allow the seller to become a tenant after the close of escrow? Inspection timelines, appraisal timelines, appraisal contingencies. Are we going to waive that contingency to say, hey, if we've offered to buy that home for $250,000 and the appraisal comes in below that, we're okay with that and we'll make up the difference and move forward? Or do we need to negotiate at that point in time with the seller to try to get them to lower that price down? Or do we meet in the middle? As you can see, moving through not just the acceptance of a contract, but the negotiations through the different timelines is very applicable. And the better negotiator you are, the better position you're going to put your clients to win each and every time. Okay, everybody, now we're going to get into presenting an offer. First off, what we want to do is we want to do a CMA. CMA is an acronym for a comparative market analysis. Earlier, we spoke about educating the buyer on the properties. So prior to doing that offer, we want to do a comparative market analysis. So essentially, we can kind of compare apples to apples, if you will, right? I have a 1,500 square foot, 3-bedroom, 2-bath, single-story home in ABC subdivision. What have those homes that are apples to apples, if you will, been selling for? Generally speaking, you also would like to have those within 90 days or less, 6 months at most. And if you're unable to find comparables within the neighborhood itself, then you do want to start to branch out on a radius up to about a mile. Once we've found the most like properties to compare apples to apples, that'll help you better educate your buyer to also formulate an offer that's not only going to be fair, but hopefully put your client in the best position to win. Number two, we talked about it earlier as well, the buyer's qualifications. If I'm ready to present that offer, we need to have that pre-approval letter from that lender, or if we have a cash buyer, we want to make sure that we have proof of funds. You'll see the acronym sometimes on a listing agreement or in the MLS that says, any cash buyers, please provide POF, proof of funds. So now that we have our approval letter or our proof of funds, we're ready to write that offer. Now, in most cases, if it's possible, we'd love to have the buyer at the office. Professional environment puts them at ease. We can also take the opportunity to review that purchase contract line item by line item, as you need to keep in mind, even though we may do this on a daily basis, this is probably the largest purchase that your client has ever made in their life, and they need to understand that contract thoroughly. So venue is very important. However, if it's not possible to have your client in the office, today you'll see a lot of digital contracts sent out. I can't stress enough, you need to have, hey Mr. Buyer, I'm going to email you the contract. Will you have 15 to 20 minutes to review that contract, where you'll have it up in front of you on the computer screen so we can review that line item for line item. We want to make sure that they thoroughly understand that contract, because if they're signing something they don't understand, that could come back to bite you. Understand the objections. Oh, market value is $250. The buyer only wants to write it for $230. Well, we need to educate that buyer on why that may not be a good idea. At the end of the day, you have to represent your client on what they wish to do. All we can do is educate them as to what we believe as a real estate professional is in their best interest. Now, there are going to be costs involved with the purchase of a home and the sale of a home. You're going to have your buyer's closing cost and you're going to have your seller's cost. Generally, a seller is going to pay any and all commissions in a real estate transaction. There are also going to be any taxes, HOAs, homeowners association. Are there any liens on the property? Title, escrow fees, transfer tax, anything like that is going to be itemized on what we call a final settlement statement. Those are the costs involved, generally speaking, for a seller. So now that we've kind of covered the essentials of presenting an offer, we're going to go into an actual residential purchase agreement. So I encourage you right now, stop, download this purchase agreement so that you can follow along line for line.